Hello guys, welcome all of you. Welcome to this discussion with respect to UPSC Law Optional Paper number 2. I hope all of you must have watched the discussion with respect to paper number 1 of UPSC 2022. And all of you must have get an understanding how should we write the answers. So I, Rajnish Jindal, will be taking you further about how you should try to attempt the answers in UPSC. Because I have come across so many queries about what should be the perfect answer, what should be the proper answer of any question. Let me just make it very clear. There is no answer which is perfect in all sense. So instead of delving into the perfection, please write down the answers. Your answers will become perfect only with the experience. So instead of going into the discussion about the perfect answer, don't indulge yourself into this kind of useless point. Start preparing and start writing. And let me just make it very clear. Even the persons who crack the UPSC, if you see their answer sheets, even they are not perfect. They are very basic. They just try to, even they know that they know the funda, how to write down the answers. So they write down whatever is required. Because you have to just write down in 150 words or in 200 words or in 250 words. Not more than that. And believe me, if you write down on an average 10 to 12 lines, 150 words are done. So by this way, please try to understand what should be the actual contents of your answer. Do not indulge into the number of cases, the section number. No. If you remember the case, it's okay. If you do not remember, it's also okay. Because instead of taking a pain or freaking out by considering that I'm not aware of this section or this case, what will happen with me? Once you start attempting the answers in the mock test, you will get an idea how you should perfect yourself in the answers. So now just let us continue with this discussion. This paper number 2, as I always say, is one of the easiest part of this UPSC law optional syllabus. You can simply start writing the answers. And this year, the paper is really very, very, very easy. Even it is not moderate. If you are aware about the current affairs, you could have attempted CLD very easily. And many of the questions are straightforward, static part of the syllabus. No technicalities, nothing. So guys, if you are very well aware about the contents, the topics, or the actual contents which you should mention in the answers, your task is done. So no need of getting worried further. Okay. So starting with this question number 1, which is one of the easiest question which we have seen this time. So the existence of mens rea along with the commission of the actus reus makes act an offense. And I think all law students, they are very well aware that it is necessary to make a crime, it should fulfill 2 elements. One is mens rea, which we call actually the guilty mind. And actus reus is, you can say, the outcome of your physical act. The outcome of your physical act. So when we say mens rea, it is actually about the guilty mind. And it has been said that you have to just explain with the help of the legal provisions and with the help of the judicial pronouncements wherever required. So it is not necessary to mention or write down the cases each and every time. But over here, I presume that all of you are very well aware about mens rea and the actus reas if you are a law student. And if not, then I just explain you the intention, the evil intention, the guilty mind, unless and until you have this intention or the knowledge or dishonestly, fraudulently. So these are the elements of the guilty mind or the mens rea. So unless and until you have this intention, this guilty mind, you do not commit any crime. Unless and until there is a concept of strict liability, whereby intention doesn't matter. Like in rape offense, intention doesn't matter. If it is being committed even without any evil intention, you are guilty. But except those cases whereby strict liability is allowed, strict liability provisions are there, like rape offense, domestic violence. Okay, so in those cases, intention doesn't matter. But if in other cases, if there is no mens rea, no guilty mind, then the person is not guilty under IPC or under any criminal law, because it is necessary to constitute a crime that you should be having guilty mind. And then we talk about the actus reas. It is the physical result of the wrongful act. It is the result actually. So you can say it is the result of your wrongful act. So by this way, first we explain actus reas, mens rea, and then you can quote few cases in support of your answer. And the landmark cases will work over here. You can mention the case of R versus Prince. So this case you can mention R versus Prince, 1875. Okay, whereby it was held that to make a crime as a crime, it is necessary that the person who has committed the crime had the wrong intention, the malevolent intention, or the guilty mind. Similarly, one of the interesting case is Quinn versus Tolson. Quinn versus Tolson. Just mention this case, and finally you can mention State of Maharashtra versus M.H. George. State of Maharashtra versus M.H. George, 1965 case. So this case is more than sufficient to explain about the importance of mens rea in any of the crime. This makes your answer complete. No need of going anywhere else. Just write it down. Seedhi baat, no bakwas. This is a fundamental of writing down the answers in UPSC. So just stick to the main points which are required in the question and your task is complete. Okay. Then you can explain that mens rea has been explained or given in the IPC in different formats like intention, knowledge, negligence, deliberately, dishonestly. So these are the few kind of degrees of the mens rea you can say. So by this way, your answer is complete. Okay guys. After that, we have been given another interesting question. What are the remedies available in the law of the torts other than the damages? Discuss citing the suitable illustrations. So I think so that generally when we read about the torts, we generally understand that in case of torts only the damages are there. But we just ignore the kind of remedies we do have in the law of the torts. So one is we have judicial remedies as well as we have extrajudicial remedies as well. So in judicial remedy, one of the remedy is damages. One of the remedy is damages. And another kind of damages, another kind of judicial remedies, you have injunction. And third, you can have specific relief or restitution. So these are the two remedies as well we do have in case of this law of torts, judicial remedy. So in case of injunction, basically you stop the person who is committing wrong against you. So injunction means to stop the offender, the wrongdoer. And specific relief or specific restitution is about getting that kind of same property which has been taken by the wrongdoer from you. And then we do have extra judicial remedies as well. So one is like, for example, in case of trespassing, so we can ask for the expulsion of trespasser. Expulsion of trespasser. So in specific cases, you can have specific remedies as well. You can also have, like if you have got the trespasser expelled from the land, then you have the right of re-entry on the land. Right of re-entry on land. Right of re-entry. Then another thing is we have the recapture of goods as well. Or recapture, you can say. Recapture of goods. So if any kind of goods have been taken away from any person through unlawful mechanism, we can get back those goods as well. Then another thing is abatement. Another remedy you can have, abatement. Like for example, if any person is committing nuisance, so you can ask for the abatement of that nuisance, to stop that nuisance. And last and final, you can say distress damage feasant. Distress damage feasant. So basically, it was a technique used by the persons in the past, whereby if the crops of any person are being damaged by the cattle, so unless and until the owner of the cattle makes the payment, so you have the right of keeping the possession of that cattle with you. So this was, you can say, distress damage feasant. So these are the various remedies. Just note it down and your answer is complete. So please understand the outcome of this discussion. How to be, smart in writing the answers. Many of the persons, they used to tell you have to mention this thing, this thing, this thing. They create actually confusion in the minds of the aspirants. And generally aspirants, they always have the question, what should I write, or how much I should write, what kind of cases I should write. No need of mentioning them. You can just simply quote an example, because they are asking only the illustrations. They are not asking about any kind of case laws. So just give the examples only. By this way, your answer is complete. Okay. Now coming to another question, analyze the effectiveness of section 326A and 326B, and specifically with reference to this Lakshmi versus Union of India case. And I think all of you must be very well aware that section 326A and section 326B, they actually deal with the provisions of, you can say, the kind of acid attacks. So these two sections are basically about the acid attacks. Because in the past we have seen that in India, acid attacks against the females, against the women, have taken place at a very higher rate. At one particular moment of time, it has been observed that nearly, in maximum of the cases or the crimes against women, maximum cases were from the acid attacks. And unfortunately, we were not having such kind of provision in our IPC earlier, because it was limited with respect to the section 326, which is about the grievous assault. But later on, in 2013, these kind of amendments were made by the parliament, and because of, the reason was basically a Lakshmi acid attack victim, actually, when she filed a PIL before the Supreme Court in 2006, asking for stricter laws or the prohibition of the sale of the acid and proper provisions with respect to the governing mechanism with respect to the sale of this asset in open or to the general public. And accordingly, in Lakshmi versus Union of India 2015, before when this case was pending, and before that the IPC was amended, and it was given, you can say, the counter sale of the chemical is basically not allowed unless the vendor kept a record of the buyer's information. This was the outcome. And dealer could sell only the chemical provided the buyer presented a government issued picture ID card, and unless and until he stated the reasons for the purchase. And even in this case, Supreme Court ruled that the victims should receive full medical aid in both public and the private hospitals. Okay. And free medical treatment should be given to such victims. And this question actually came because recently we have seen in another case, there was a case in Maharashtra, state of Maharashtra versus Ankur Narayan Lal Pawar. State of Maharashtra versus Ankur Narayan Lal Pawar, 2019 case, in which the accused was originally given a death sentence by the Session Court of Mumbai in 2016 for hurling the acid upon a woman who had rejected his marriage proposal. But in 2019, the High Court, Bombay High Court, commuted the death sentence of this accused to the life imprisonment. So this thing also, came in picture once again. Because if you go by this section 326A and 326B, they provide the harsher punishment for this acid attack. Now the question is, because they are asking about the, if you focus upon its effectiveness. So in this case, we come to know that in India, even after the stricter law and even after the guidelines laid down by the Supreme Court in this Lakshmi versus Union of India case, what we have seen, the pathetical state of the sale of this acid still in open. Because even recently what we have seen, there is number of cases of this acid attack. No doubt the number has gone drastically low, but still this is happening. And in the remote areas or even in the rural areas, and even in few cases of the urban areas as well, we do see that there is an open sale of this acid. Even I can vouch this because I was, when I was going somewhere, I was seeing that on a rickshaw, a person was openly carrying the acid in the bottles. So the point is the effectiveness, because we come across a number of news on daily basis, that even after the insertion of these two sections, which have clearly criminalized the acid attacks. So, and another section 326B basically about the attempt to commit acid attacks. So these 26A and 26B, we have to just mention these two sections first, and then we have to mention about the effectiveness. And this is a little bit about the Lakshmi case and the Supreme Court guidelines, okay. So the point is, even after such provisions and the guidelines laid down by the Supreme Court, in many parts of this country, open sale of the acid is still taking place. And because of that, even there are a number of reported cases of the acid attacks. And for that purpose, we can mention what should be the better solution, but this is not given in the question. But for the sake of your answer, even if you have the space, you can mention this, otherwise no requirement. Because ultimately the effectiveness is, you can simply quote the data if you have this data with you. Otherwise, no need of mentioning that, but you can simply mention that still the sale is taking place in open without maintaining the record as well. Because the issue is, this country is very large, and because of that, to keep a checks and balances at every point sometimes becomes practically impossible. But we should hold at least someone responsible for this sale. So the proper enforcement mechanism, because we cannot take this leeway that it is not possible to manage everything. We have to basically manage all these things. But the point is, there should be some strict measures at the ground level, because now laws are there are clear-cut provisions, but the ultimately effectiveness at the administration level. So every DM or DC, they should be held responsible for the proper enforcement of the Supreme Court guidelines. And ultimately, we can simply conclude still the issues of the asset attacks are taking place, but the incidences have done drastically low. So this is also one of the point you can mention in your answer. Then, how for Section 7A of the Protection of the Civil Rights Act 1955 been effective to control the untouchability in India? We know very well that Section 7A of this Protection of the Civil Rights Act 1955, first we have to mention about this Section 7A. It is a very straightforward question. Actually, this part is very static. And then how far it has been effective. So first you have to mention what is this provision all about. So this provision is basically unlawful compulsory labor when to be deemed to be a practice of untouchability. Compulsory labor. So Section 7A, subsection 1, it says, whoever compels any person on the ground of untouchability to do any squenging or sweeping or to remove any carcass or to flay any animal or to remove the umbilical cord or to do any other job of a similar nature shall be deemed to have enforced the disability arising out of untouchability. And for that purpose, the imprisonment shall not be less than 3 months and not more than 6 months, and a fine of ₹100. So when we talk about the effectiveness, you have to also mention about Article 17 as well, which talks about the untouchability should not be there because it has conferred a fundamental rights. And then you have to just mention about the Section 7A and Article 17. Now the question is whether this particular provision is effective or not. So it is not necessary for you to quote any kind of data or facts in this regard because it is not possible to keep the data of each and every points. So you can just give the answer, whatever you have seen. So UPSC is not concerned that you should quote a specific data from a reliable source. No. Whatever you have seen in your life or whatever kind of articles you have gone through. So if you have such kind of, data or some kind of information with you, just quote that. So Article 17 and then Section 7A, and then you can quote your experience because it is only about your view. So whether this untouchability with respect to this forced labor has been reduced or not. So we can say that, like for example, if I have to give this answer, the conclusion, then in my words, I can say that the compulsory labor on the grounds of untouchability, because it is not compulsory labor only, it is compulsory labor on the grounds of untouchability, Section 7A. So this has gone low and the cases are very less, or you can say this kind of untouchability has been effectively eradicated from this country. But there are some instances of such kind of cases in rural areas or in the remote areas of this country, and the stricter implementation of such provisions are necessary. But we do agree, and all of you should be agreed with this point, that this kind of untouchability with respect to this forced labor is, not happening in this country anymore. Only the few cases, if you have seen, then you can just mention by giving your experience, otherwise no requirement of going into that. So you can simply conclude this in your own words, okay? So sometimes in the lack of any specific data, because we even only in a few exceptional cases, we are not witnessing such kind of thing. So it is totally up to you how you write down this answer in your own words, because it is just about your experience or about your kind of knowledge, nothing else. Moving towards the next point, the right of private defense is based on the cardinal principle that it is the primary duty of the man to help himself, but this right is not absolute. So we have been given section 96 till section 106 of IPC, the right to private defense, RPD. And we also know very well that this particular right to private defense, first of all, you have to just mention what is this right of private defense is all about, and then you can quote few examples like how this right to private defense is being created. Okay, and then you can also mention one of the cases in which it has been clearly given that why this right to private defense has been given in this system. And one of the landmark case in this direction is basically James Martin versus State of Kerala. This case you should quote. 2004. In this case, Supreme Court has held that it is the primary duty of every human being to protect himself first. And then you can quote about the guidelines laid down by the Supreme Court in state of, Jagdish versus state of Rajasthan. Jagdish versus state of Rajasthan, you can quote over here. Okay. In which Supreme Court has laid down that the right is basically available to the persons only in the justified circumstances, only for the purpose of defense, not for the purpose of revenge or not for the purpose of retributive purposes. The harm inflicted upon the person should be reasonable, and the burden of proof is only upon the accused to prove that why this right of private defense has been used by him. And then you just start writing about what is right of private defense, what are the provisions where it has been given. Then you have to, because the statement is very specifically mentioned, then you have to quote this case, James Martin versus State of Kerala, and then the guidelines of the Jagdish versus State of Rajasthan. By this way, your answer is complete. Because all these are 10 marker questions and you have to just write down in 150 words only, maximum. So by starting to write down the right of private defense given in IPC, the purpose, the cases, and then the outcome. Simple. No need of going into the further into this particular point because it is very lengthy chapter as well. The kind of parameters or the provisions. So these are very lengthy. So don't indulge into all these things, okay? The state liability under the law of torts has undergone metamorphosis. Explained with the help of the case laws. So when we talk about you can say about the state responsibility, we can quote exactly the kind of the state liability first, because it is about the vicarious liability. So vicarious liability of the state, we are talking about this. So vicarious liability. Why vicarious liability? First explain vicarious liability, then explain vicarious liability of the state, and then try to mention the sovereign and the non-sovereign functions of the state, because this was the only criteria of differentiating when a state is responsible. So your answer basically should be in light of the decided cases whereby you have to just explain the kind of constitutional remedies and the legal remedies the persons will have against the government. So Article 32, Article 226, you can quote over here about the state responsibility. And then when you will be mentioning the cases, we have been given so many cases, you can quote any of the case. and one of the case whereby the differentiation between the sovereign and the non-sovereign functions, and the in case of non-sovereign functions, the liability of the state has been categorically mentioned. State of Rajasthan versus Vidyavati. So this case you should try to quote, and you can mention about little bit facts of this case. Okay, whereby the the Kasturi Lal, the seizure of the property by the police, and then the taken away of this property by the policeman, and whereby how this case unfolded the responsibility of the state and the demarcation of the sovereign and the non-sovereign functions. So this case is only sufficient for your answer. Otherwise, you can mention the recent cases as well. However, if you are done, because this is a 20 marker question, so we have to write down only in this context. So first vicarious liability, then liability of the state, and then the differentiation by mentioning this Vidyavati case, and then you can quote other cases as well, and this will make your answer complete. We have been given so many cases. So N. Nagendra Rao versus State of Andhra Pradesh is one of the case whereby the doctrine of sovereign immunity was was challenged before the Supreme Court, and Supreme Court has held that the doctrine of sovereign immunity has no relevance in the present day context with the concept of sovereignty itself has undergone drastic change. And the ultimate criteria of this differentiation was the kind of non-sovereign functions government performs. So for the non-sovereign functions of the government is responsible. So in every kind of cases, the ultimate point of discussion is the differentiation between the sovereign and the non-sovereign functions, and by thereby, if you remember other cases, it is okay. If not, then with the help of the recent examples, you can try to give the answer of this question as well. Okay. Now, because in this question there is nothing as such you can write down over here, but only by writing these points your answer is complete. So do not indulge unnecessarily in expanding the scope of this kind of answer. Okay. Then the provisions of section 149 of IPC and section 34, which is about the unlawful assembly and the, you can say, common intention, is one of the important question of IPC, whereby you have to quote what is section 34 and what is section 149, and then you have to quote the judgment whereby Supreme Court has mentioned the differentiation of these two sections. Nanak Chand versus State of Punjab. Nanak Chand versus State of Punjab, whereby Supreme Court has laid down the differentiation between section 34 and section 149, because section 34 does not create any specific offense. It only provides if the persons they share the common intention before commission of the crime, they all will be responsible for the same crime. So it doesn't matter whether the crime was actually committed by anyone else or another person was just doing passive work, it doesn't matter. If the persons were having the common intention, they all are responsible for the same offense. So basically the active participation is necessary. Okay, so active participation means simply, when I say passive, it doesn't mean that you shouldn't participate. Like for example, if two persons are going for committing the theft, and one person is actively committing the theft and another person is just standing at the gate to keep a watch whether someone is coming or not. So even this small act of that person will make him guilty for the offense of theft. So this is the actual meaning of the participation. So this participation should be there. And for the common intention, we have to prove that there was a pre-arranged plan, a meeting of minds. Meeting of mind is compulsory for section 34. And the common intention is the essential element over here, the pre-arranged plan, the pre-concert of mind. While when we talk about the section 149, it creates a specific offense.
of being a member of unlawful assembly. If there are more than five or more than five persons, and if they are into commission of any crime, so thereby even the mere membership of this unlawful assembly is sufficient. So basically, it doesn't require any prior meeting of minds. It only requires if five or more persons they are into commission of any crime. So being a part of the unlawful assembly makes you responsible for that crime as well. So by this way, you can quote differentiation between these two sections and then conclude your answer. So no need of further writing down anything else. Section 34 explanation, section 149 explanation, then the difference with respect to this case, and then the differentiating parameters. That's all. How is the rule of absolute liability different from the strict liability? Cite the relevant judgment. We know very well that in case of strict liability, which is a provision of you can say this common law of England, which is the common law of England, and absolute liability is the refined version of our country. So the idea behind the strict liability was that if any, first you have to explain strict liability, then you have to explain absolute liability, and then you have to explain the number of cases by which this absolute liability become a rule in our country, and then you have to mention the exceptions. So basically, starting with this strict liability, we have to mention Reynolds versus Fletcher rule, whereby this strict liability was laid down. Okay, and then in absolute liability, because in strict liability we do have some exceptions, but these exceptions are not applicable in case of absolute liability. So first you explain what is strict liability. Because of this Reynolds versus Fletcher case, this strict liability came into picture in 1868, whereby if any person keeps any hazardous kind of substance on its premises, and if that substance escapes the premises and causes harm to another person, so you have to compensate that person. So this is basically, you can say, when you are using the non-natural use of your land by keeping dangerous substance, and if that dangerous substance escapes the premises, then it is your responsibility to compensate the affected person. So these are the three conditions for the strict liability, but we have been given exceptions: the act of God, the fault of the plaintiff himself, statutory act, or the act of stranger, or the mutual benefit. These are the five exceptions which you have to mention in your answer, because if these exceptions are proved, then the person will not having the strict liability. But in India, the Supreme Court of India has gone for the absolute liability principle. So in case of India, in Bhopal gas tragedy case, and even in case of Shriram Food and Fertilizers case as well, what we have seen that in India, because of the illiteracy of the persons, because of the poorness of the persons, because of the kind of demographic we have, so the persons are basically not, able to cope up with this kind of strict liability which is applicable in UK or in some other developed countries. So basically, by looking at the situation of the persons in this country, Supreme Court simply said no exceptions are applicable. So it is just a difference of exceptions actually. So in absolute liability, no exception is applicable, and you have to make the payment of the compensation to the affected persons, even if it was not your fault. Because ultimately, the reasoning is basically you are getting benefits from keeping that, the item with you in your premises. So you are getting profits, but in case of losses of the third parties which are not of your, which are not concerned with you, So they should be compensated. This is the main idea of this absolute liability. So by mentioning these points, it is done now. Okay, you can quote these as much as cases of environmental law, MC Mehta cases or Shriram Food Fertilizer case you can mention, or any other case whichever you find suitable to your knowledge at that moment of time. Now coming to what do you understand by unlawful assembly? Discuss the circumstances when the lawful assembly becomes unlawful and suitable illustrations. It is once again a very simple question. You can simply write down first of all what is unlawful assembly. Section 141 of the IPC and the common object. So the main idea is basically common object. If the common object given under section 141 of IPC falls under the 5 given parameters, then the lawful assembly converts into the unlawful assembly. Otherwise, any kind of assembly is lawful unless and until they have the common object to commit the 5 given kind of offenses which have been given in section 141. So by mentioning section 141 and the focusing upon the common object and the 5 categories of the offenses which can be committed by the members of this lawful assembly, will make this lawful assembly as unlawful assembly. The simple way of writing this answer. And then you can quote few examples over here as per your suitability, and you can mention few cases over here as well. The Pandurang Thackeray versus State of Maharashtra. You can quote this case. Okay, you can also quote the case of Muthu Naikar versus State of Tamil Nadu, or whatever case you remember at the time. So whatever case you can mention, otherwise try to mention the examples, illustrations only. So your focus should be upon section 141, common object and the 5 categories of the offenses which the assembly commits. Then the lawful assembly converts into unlawful assembly, and then in each and 5 categories of those offenses, the common object actually, the purpose of this assembly, just mention that with the help of quoting simple illustrations, because it is a 20 marker question. So when you start writing those 5 categories of this common object, it will complete this answer. Okay. Now moving towards another question. The right of reputation acknowledges as an inherent personal right of every person. Discuss a statement in the light of the law of defamation in India. So basically, what do we have to mention over here? We have to mention about the law of the defamation, which has been given in section 499, section 500 of IPC, and your focus mainly will be upon section 499 and the exceptions. But first you have to explain why the right of reputation is necessary. For this purpose, one of the cases basically, because it originated through this law of England, so we can mention one case over here, R versus Robinson. R versus Robinson. Which is of 1971. You can mention this case over here. And first you just try to explain why this reputation is necessary. In this case, one of the landmark case of the Court of India you can mention, Dr. Mahmood Nair versus Mahmood Nair Azam versus State of Chhattisgarh. (2012), whereby the importance of reputation has been explained. So Supreme Court has said that reputation is a facet of right of life as engrafted in Article 21. So this right of reputation is a part of, you can right to life in Article 21 as well. So this particular mentioning of this case and article will make or will emphasize upon your answer. And then you can mention about this section 499, then the exceptions you can mention, and then you can conclude by mentioning the constitutionality of the provisions to defamation, whereby you can mention the case of Subramanyam Swamy versus Union of India. Subramanyam Swamy versus Union of India, 2016, whereby it was held that the main provisions are basically given from section 499 till section 502. So this was challenged actually, and the court observed the constitutional validity of these provisions with respect to defamation. The reputation of a person is an intrinsic and most precious right to life guaranteed under Article 21. And it is for the protection of this right, section 499 till section 502 are drafted. And nobody has the right to denigrate others' right to person or reputation. Finish. It will be your concluding remarks. Simple. The consent of victim, next question, negates the offense of the rape. Consent. How it is, how far it will be true if it is obtained by the offender on the false promise of marriage. So first of all, just try to understand what will be the contents of your answer. Because first we have to mention about section 375, which talks about the offense of rape. Then you have to mention about, so first section 375 of IPC, section 114A of Indian Evidence Act, and then one of the interesting case in which this particular judgment was given by the court is Dilip Singh versus State of Bihar. Dilip Singh versus State of Bihar, 2005, whereby the facts were that one person, on the pretext of having marriage later on, entered into this sexual relationship with a girl and later on denied. So the point is basically, what is the meaning of consent? So for that purpose, you have to refer specifically section 375 clause secondly, without her consent, then thirdly, fourthly, fifthly, so and then sixthly as well. So when you mention those circumstances under section 375, which talks about when her consent is being taken, so mainly under section 375, secondly, without her consent, which is having very wide ambit. So in the pretext of giving any false promises, if you commit any sexual relationship with the girl, in that case the burden lies upon the accused under section 114A of the Evidence Act to prove that the consent was taken without any force, without any coercion, without any compulsion from the girl. Otherwise, the accused will remain responsible. So in this particular kind of answer, you have to first mention about section 375, section 114A of the Indian Evidence Act, then this Dilip Singh case, because it was a landmark case whereby it was held. But even you can also mention, if it is being proved by the accused that this consent was taken without any kind of force, if it is proved, because the burden of proof is upon the accused only. Because if the girl says under this section 114A of the Indian Evidence Act that I did not give my consent, so court will presume that yes, it was without her consent. And the issue of the consent actually came in one of the interesting case, which we call Mathura case. Mathura case, 1979, Tukaram versus State of Maharashtra. So, and another case, State of Himachal Pradesh versus Mangoram, or Mangoram you can say. State of Himachal Pradesh versus Mangoram case of 2000. Okay. So you can mention about this consent as well over here. So this will make your answer complete in this way. Okay. So by understanding all these points, I think you should be getting an idea. You should be very well clear about the contents of your answer. And then no panic, nothing, no fear. Start writing the points. Even if you are not been able to write down the exact ditto wording or the verbatim of sections, don't worry. Write down the main points. That will be more than enough. Okay? Because you are the human beings, not the machines, not the robots. So behave like a human being only. Then summarize the law relating to the attempt to suicide and the Mental Health Care Act 2017, the new dimension to the law of the attempt to suicide in India. So first of all, what we have to mention over here, first we should mention about section 309, which is about attempt to suicide. So how this attempt to suicide has been given as an offense, whereby simple imprisonment for 1 year has been given, but by the enactment of this Mental Health Care Act, now it is no more an offense actually. And even before that, I just mention you few cases. In Maruti, please note down the case. In Maruti, Shripati, Dubal versus State of Maharashtra, number 1. Number 2, in P. Ratinam versus Union of India. And in third case, Gyan Kaur versus State of Punjab. (1996). These 3 cases you should quote first before writing about the Mental Health Care Act. In first Maruti case, it was held by the Bombay High Court that section 309 is violative of article 14, 19 and 21 of the Constitution. Then in case of P. Ratinam as well, Supreme Court held that this is in violation of article 21. And in Gyan Kaur case, Supreme Court held that the section 309 is not violative of article 14 and 21. It is not violative of the Constitution, article 14 and 21. But over here, court overruled all these previous judgments and they once again established the section 309. But with the enactment of this Mental Health Care Act, the situation has been changed. So under this Mental Health Care Act, if you do remember any facts at that moment of time of the question paper, you can mention that, or you can simply mention about the way under which this Mental Health Care Act, how the victims, or you can say how the persons are being treated. So the right of the persons with the mental illness, because of this enactment of this law, now persons are not being considered as an accused, but they are considered as a victim, okay, of the mental illness. So if you go by any kind of survey or any kind of data with you, you can just quote that. If you are not aware about this data, so just leave it. You can mention that the reasons behind commission of the suicide, and then you can mention about what is the ultimate outcome of this Mental Health Care Act, by which persons are being guided actually, not punished. So now the punishment is no more there. So by the enactment of this Mental Health Care Act, ultimately this section, you can say attempt to suicide is practically has become ineffective. So ultimately now it is the duty of the courts as well as the government to take care of the mental illness of that particular person. Because if any person is committing the suicide, so we have to just take care of his mental health care. So by referring the provisions of because otherwise before that we have Mental Health Care Act of 1987 as well. But by the enactment of this new act, whereby the patients have been given right of access to the range of the mental health care facilities, and like inpatient and outpatient services, rehabilitation services in hospitals, in community, at home, and sheltered accommodation and supported kind of accommodation, they all are the services given under this the Mental Health Care Act. So just mention that and just try to conclude whether it is effective or not. So this is in your words only. Okay. If you do remember any data, any facts, you can quote that. If you do not remember, just leave it. Okay, just try to just mention what are the benefits of this Mental Health Care Act that you should be aware in your GS paper as well. Okay. So by this way, your answer is complete. Now outline the legal framework of the protection of the online consumers under the Consumer Protection Act and the Consumer Protection e-commerce rules. So basically, the government of India has enacted in this new Consumer Protection Act under this Consumer Protection Act about the, you can say, how the online, whenever you make any kind of this online purchase, so how exactly a consumer is being protected. So in this case, first of all, you have to just mention about the e-commerce meaning given in this Consumer Protection Act, whereby the definition says buying or selling of the goods or services over the digital or the electronic network, including digital products given under Section 2, Clause 16. If you do not remember section, leave it. Just try to mention in your own words what exactly is the meaning of, you can say, e-commerce under the CPA. And CPA is one of the landmark law right now, we can say, for the protection of the consumers, and whereby government has basically drafted number of the guidelines with respect to the consumer protection. So you have to just, if you are aware about these kind of the protection given in this e-commerce guidelines, basically with respect to this consumer protection, you can mention that, whereby I just, the simple focus of yours should be upon the consumer protection e-commerce rules framed and how this protection of online consumers under this CPA has been given. So first of all, you have to just mention about the CPA, little bit about the CPA, and then your focus mainly upon the guidelines or the rules under this particular CPA. So basically, the e-commerce rules, they prescribe the elaborative framework for the regulation of the e-commerce entities actually. And what is e-commerce entity? It has been clearly defined that any person who owns, operates or manages digital or electronic facility for the electronic commerce. So that person will be an e-commerce entity. So or you are supposed to just mention about simply the provisions, and whereby you have to just try to explain, like for example, the provision with respect to this explicit and the affirmative consent of the consumers, number one, then the price manipulation, then the treatment of the consumer discrimination or the disclosure of the preferential treatment to the sellers, cancellation charges, timely refunds. Now, if you see that on Amazon or Flipkart, you just get more detailed information. All these have happened only because of these rules. Even the grievance redressal officer mechanism was one of the greatest point, and the nodal person of contact to whom we should contact, and the timely redressal, a complaint token, kind of all these kind of things, and fair or misleading advertisements and disclosure, all these kind of information have been clearly given in those rules. And because of that, now consumer is more empowered. So just mention all these kind of rules and regulations and your answer is complete. Okay guys? Now, tortious liability arises from the breach of duty primarily fixed by the law, and the duty is towards persons generally, and its breach is redressable by an action for unliquidated damages. One of the very simple, straightforward question. First, you have to just explain what is tort, how tort came into picture, how it basically provides a framework of the breach of duty primarily fixed by the law, and this duty is towards the persons generally, and its breach of redressable by an action for unliquidated damages, because in case of law of torts, the damages are not calculated at the first point, so they are calculated later on. That's the reason we call them unliquidated. So in such case, I recommend how to write down the answer in such kind of question. First, try to explain what is law of torts, how it become a particular, how it become a law, and how exactly it works. And the historical origination, as I teach to my students, the bought and the boughtless kind of wrongs against the persons in the society, and those bought and the boughtless, they later on become civil and the criminal law. In criminal law, it is obviously necessary to define each and everything in the very beginning. But in case of civil law, it is of three categories: torts, contract, and the trust. So the tort is basically the kind of law where there is a vacuum, where no, everything cannot be decided. And it is not like that torts is not codified. Torts is also codified in different aspects like Motor Vehicles Act, Consumer Protection Act, Competition Act. All these are the domains of the law of torts. So your duty is basically to just try to explain with the help of, like, for example, generally like negligence or the nuisance. So just quote these examples and try to explain how nuisance or how negligence or how trespassing will become a wrong against the persons generally. So by quoting these examples, just try to conclude how this law of tortious liability is actually applicable in our country. Simple. So by discussing all these points, you must be getting an idea. It is not always necessary to be technical each and every time. Be smart and just understand how to write down the answers with the reasonable contents. Do not unnecessarily make the things complicated, because what I have seen at many point of times, generally people make the things very complicated, and that is the reason aspirants, they fail to understand or they get confused whether I'm writing a better answer or not, or perfect answer or not. This is perfection is a misnomer. Perfection, just ignore it. Okay. Now, next question is, answer the following in about 150 words. All the contracts are agreements, but the agreements are not contracts. You guys, the persons who have given this paper right now, they are very lucky. You have to just explain for the stages of entering into a contract. Stages. Like first, there is one proposal, acceptance, which becomes promise, then consideration is necessary, it becomes agreement, then the essentials of the contract. That person should not be minor, there should be consensus ad idem, the parties must be clear about each and everything. So these are the few conditions. There should not be force or fraud or coercion. So by fulfilling all these elements, you reach to the stage of contracts. So you have to just mention down the stages of the contract, how you basically enter into a contract. So this stage, so if you are not fulfilling the essential elements of the contract, it will stop at the level of agreement only. So by this way, you can simply quote and write down why all agreements are not contracts, but all contracts are agreements, because it is the further stage of the contract. Okay. So in this case, I don't think so that I should say anything else. Discuss the quasi-criminal nature of section 138. For this purpose, I recommend all of you, even I teach to all my students, if you observe the chapter 17 of NIA, which talks about section 138 first, the purpose of insertion of this chapter 17 into this Negotiable Instrument Act was to support the economy, because if checks keep on failing, because the entire ecosystem of business, it operates on trust, and if trust is breached, if there is no trust, then obviously entire system will collapse, entire economy will collapse. So to maintain the trust in the society, it was necessary that you should have some kind of force, so that the person, the defaulter, should honor their promises of making the payment. And if payment doesn't take place properly, this economy will suffer a lot of damage. So the trust factor, the requirement of trust in this economy, and then ultimately the kind of you have to just mention that section 138 has a special characteristics, because it is criminal as well as quasi-criminal. Why? Because it provides punishment in the form of 2 years imprisonment and 2 times of the fine, but as well as it also provides for the compromise. compromise at any level of case, even before the judgment of the case, even after the judgment of the case as well. So this kind of promise, the compromise, is one of the greatest feature which makes it quasi-criminal in nature. If it would have been purely criminal, then the settlement or the compromise cannot happen after the judgment. But in this specifically section 138, compromise can happen at any level of case, even during the trial or at the time of judgment or at the time of the imprisonment as well. Parties can compromise and the matter will be over then. So this is the way it is quasi-criminal in nature. Okay guys, I hope so you must have get an idea. Rest I will discuss this particular point because I have made it very clear to all my students that this question will definitely come in the exam. Okay. Then discuss the implications of the high level committee known as the TSR committee report of 2014 and what are the environmental the review. Actually, I don't know how many of you are aware that this particular committee, this committee submitted its report in 2014 about the environmental and the forest governance in the country, and it also emphasized upon the Indian environmental services as well. So the Tsr Subramanyam Report, when this committee was established by the central government by the former cabinet secretary Tsr Subramanyam to review the processes, laws and the acts of the environmental ministry. So this committee set up its report in November 2014. Why this report is basically, this question has come recently because it is a part of CLD, contemporary law developments. And that is the reason this question came right now, because right now the environmental ministry has made a statement that they are implementing all the recommendations of the TSR Subramanyam committee. The environmental, or even this statement was given by the ministry in the beginning of this 2022. So this question came because of this outcome, or you can say the application of this implementation of the TSR committee, TSR Subramanyam committee recommendations, which actually said, the kind of recommendations. So you just try to mention how these recommendations are being applied by the government of India. I give you brief hint only. The ministry in March last year, they commissioned a private law firm to draft a new environmental management act, which will act as an umbrella law covering air, water and environmental acts. In October last year also, ministry released a consultation paper on amending the Forest Conservation Act 1980. And similarly, ministry in line with the committee's recommendation is in the process of implementing a single window clearance process for all kind of clearances pertaining to the forest, environment and wildlife and coastal regulation zones. And the average time which has been earlier, was very high. It has been lowered now 90 days in 2021. And the ministry has also plans to rank states on the speed with which they accord environmental clearances to the development projects. So these are the few kind of recommendations of the TSR Subramanyam committee which have been implemented by the government of India, and that was the reason this question came this time. So please keep a close watch on the topics of CLD, because in CLD you are not supposed to go through the basics of all those subjects, only the latest news. So this is the way you prepare for CLD. Okay guys? Then elaborate the conditions and warranties provided under the Sales of Goods Act. So I hope all of you are very well aware about the conditions and warranties. So first you can explain what are the conditions, what is the meaning of condition, what is the meaning of warranties, and then you can just write down the difference between the conditions and warranties. So ultimately, you are just supposed to have the basic idea, the different kind of conditions and warranties we have been given under the Sales of Goods Act. So basically, we can write down the Sales of Goods Act, specifically section 11, which talks about the stipulations as to time. But please keep in mind, you have to just explain what are conditions and what are warranties. The conditions by which no agreement would have been entered into, and the warranties which are just supplementary in nature and which were not so much necessary for the entering or for the coming of the agreement into picture. So section 11, 12, 13, 14, 15, 16, you can mention all these sections in support of your answer, and section 17 as well. So section 11 till section 17 of SOGA, you can mention over here, which talks about express and implied conditions and warranties one by one. So by this way, you can write down this answer. But please keep in mind, first explain what are conditions, what are warranties, and difference between these two things. And then try to explain the different types of conditions and warranties given in the SOGA from section 11 till section 17. Okay? The quotation from a work which has already been lawfully made available to the public does not constitute infringement of the copyright. It is about the fair use. Section 54 of Copyright Act. So all of you know very well the section 4 of the section 54 of this section 52, sorry guys, section 52 of this Copyright Act, which talks about the doctrine of fair use. Okay, so section 52 of the Copyright Act, as well as you can mention about the Berne Convention, Article 10, as well as Article 13. And you can quote the example of this, the case of this Delhi University, whereby the photocopier, when they were using the, the study material by copying that from, the books of Oxford and the Cambridge universities, and they were preparing the notes, the class notes actually. So you can quote that case as well, and you can mention, first you just mention about the section 52 of the Copyright Act 1957, whereby it has been given like in which scenarios it will be a fair use actually, fair use. You can also quote Berne Convention if you remember, otherwise section 52 is more than sufficient for you. And then you can quote few cases which we have seen in the past, whereby Supreme Court has laid down that what is the fair use in Copyright Act. So this is just the answer of yours. So section 52 and Berne Convention, Article 10 and 13, and this Delhi University case of the photocopier, Oxford and the Cambridge University. So this is more than sufficient for you. The liability of the surety is coextensive with the principal debtor. So in such a case, now we have to just mention about the provisions with respect to the liability of the surety and the principal debtor. So I just tell you the relevant sections which you can mention over here. Okay. And how you can just write down such kind of answer, because these are the static kind of questions only. Okay. So for this purpose, you can refer section 126, which talks about of Indian Contract Act, section 126, which talks about, first of all, the surety and the principal debtor and the creditor, and then the kind of the essentials for which the kind of discharge of the liability and the liability of the surety as well. So for this purpose, you can refer section 130, 131, 133, 134, 135 and 139. So I repeat once again, discharge of the liability of the surety. For this purpose, you can refer section 131, section 130, section 131, section 133, section 134, 135 and section 139. These are the few sections you have to first mention about when the surety will be discharged and when he will not be discharged. So for that purpose, you can quote section 136, 137, 138. So basically it is mainly asking about the liability of the surety when a surety is also responsible. Okay, so when the ultimate point is, why do we enter into the contract of guarantee? So in this case, you have to just start explaining the role of the surety in a contract of guarantee. This you can quote for this from the section 126 actually. And then the focus should be, first of all, you have to focus upon this line, why this statement is basically talking about when the surety is discharged and when he is not discharged. So just he is not discharged in these three cases, and over here he is discharged. Okay. So by quoting this example, these the sections, you can just simply write down when surety is discharged and when he is not discharged. So just make it very simple. Okay, do not make the things technical or complicated. What do you mean by abuse of dominant position and the abusive conduct? In Competition Act, this is actually section 4. It is actually section 3. So they have very smartly, they have given the nomenclature, the abusive conduct, section 3 actually. So it is about the anti-competitive agreements. Anti-competitive agreements, section 3, and section 4 is about abuse of dominant position. So if you guys are clear about what is this abuse of dominant position under section 4 and the parameters, so section 19 as well you refer over here of the Competition Act. Okay, so section 3 first try to explain the anti-competitive agreements which are actually abusive conduct, and the abuse of dominant position under section 4 when a company or enterprise is into dominant position and when they are abusing it. So you can take a reference of section 3 and 4 and section 19. It will make your answer complete. So in the classroom program, we explain this particular section 3, 4, 5, 6 and 19 and 20 mainly. Because in UPSC, in the past years, we have seen only such kind of questions. So you play just, smartly by covering section 3, 4, 5, 6, 19 and 20 of this Competition Act, and then this Competition Act is complete. Or competition policy or the amendments in the competition law recently have taken place. So this might be a question for the next time. So this is a very static portion. No need of mentioning any other thing. So just mention section 3, how they are entering into the anti-competitive agreements, how they are basically abusing their dominance position, with the help of section 19, whereby the parameters of figuring out these kind of conduct are given. Section 19, subsection 3 and subsection 4, mainly for your reference. Okay. Now next is, dwell on the concept of emergency arbitration in providing relief in India. Actually, the recent case between the Amazon and the Future Retail, this emergency arbitration came into picture, this word actually, otherwise it was not there earlier. So in the recent case of arbitration between this actually Amazon and Future Retail, so it was held by the Supreme Court that what is emergency arbitration actually? So when we talk about the emergency arbitration, it means when parties, they need an urgent interim relief before the constitution of the arbitral tribunal. So basically, whenever there is any emergency requirement of the relief, so the interim relief which have been given under section 9 and 17 of this Arbitration Act, and similarly when we talk about the section 37 of the Specific Relief Act. So the point is, whenever the parties, they just want to have some kind of emergency relief to avoid the substantial losses of their business transactions, so generally they enter into such kind of emergency arbitration. So basically the sole objective of this emergency arbitration is to provide the urgent relief to the parties before the tribunal is being set up. Because generally when we enter into the arbitration, it takes time to set up the tribunal, and then tribunal will start working. So before the setup of the tribunal, we do require some interim relief. So these interim reliefs in emergency case are known as emergency arbitration, and you can simply quote few instances of this Amazon case if you remember. Otherwise, just quote this case as well. Okay. So you have to be very well aware about section 9 actually. So section 9 will serve the purpose. And just go through this section 9 of this Arbitration and Conciliation Act 1996. Okay guys? State the circumstances of supervening impossibility and frustration of the contract in the light of the decided cases. So guys, I hope that all of you must have gone through this supervening impossibility, and now please try to understand why this particular question came right now. The reason is because during the COVID pandemic, what we have seen that because of this COVID outbreak, we have seen that in India, not only in India, but across the world, we have seen a situation whereby the contracts were frustrated, means they were not being able to perform the promises. So the provision of, you can say, supervening impossibility first, which has been given clearly in Indian Contract Act section 56 and section 65. So when we talk about the doctrine of supervening impossibility, so you have to just start first of all explaining supervening impossibility. Refer section 56 and section 65 as well, and then try to explain the frustration of contract, and then you can quote the cases as well, because it is based upon that law does not compel the impossible. It is a Latin maxim actually, lex non cogit ad impossibilia. So law does not compel the impossible. So basically, the doctrine of this supervening impossibility provides, or the doctrine of frustration given under section 56, which says that in few specific cases when a particular promise which is to be performed become impossible because of the factors which are not under the control of the parties, then law cannot compel them to fulfill those promises. So first try to explain section 56, section 65, and then try to mention the cases. We have few cases like Satyavarta Ghosh versus Mugni Ram Bangur and Company. Then you can mention Shushila Devi versus Hari Singh case as well. And try to explain the types of the supervening impossibility, like for example, destruction of subject matter, death, illness or personal incapacity of the parties, change of the law, declaration of war, non-existence of the particular state of the things. So just mention these points and try to write down this section 56, 65 and the landmark cases which I have just mentioned you, and your answer is complete. That is more than enough. Actually, it is about the IT Act versus consumer protection. This is not a basically you can say direct question. It is little bit top, little bit kind of technical point. So over here you have to compare the IT Act versus consumer protection. Like how IT Act is not been able to provide the consumer protection in e-commerce actually. Because ultimately when we talk about the IT, we are talking about the e-commerce. And then you can also mention that CPA and the concerned guidelines made in 2020, they are serving this purpose. But IT Act is silent about that. Okay. So generally, when we talk about the e-commerce transaction and the role of the IT Act to control this e-commerce, we come across so many kind of difficulties. Like for example, confidentiality of the information of the seller, identity of the seller, the insecure payment methods, risk and misuse of the personal information, data privacy, and also effective grievance system and the legal remedies, and the unsafe products. Then the issue with respect to the completion of transactions, the payment failure. These are the few issues you have to just mention, and then you have to explain that IT Act is silent about all these points. But these have been taken care by the government through the Consumer Protection Act. But IT Act does not provide a direct remedy to the consumers in this direction. So ultimately, we have to be dependent upon the other laws, other provisions. And your conclusion should be about how this IT Act should be amended, or there should be some guidelines laid down by the government to regulate the e-commerce transactions with the help of the IT Act and the rules as well. So this you can just mention in your answer. Okay. An agreement without consideration is void. Any exceptions? So you know very well, the consideration is the most essential element, and without consideration, any kind of agreement will be void. But we have been given few exceptions to this particular point of consideration as well, and then you can start quoting those exceptions, whereby first you have to explain the importance of consideration, because once one promise is made coupled with the consideration, then it becomes agreement. But if there is no consideration, then ultimately the agreement will become void. Section 25 of the Indian Contract Act. Number one. Then exceptions. So it also provides exceptions as well. So exceptions are given under section 25, subsection 1, which talks about natural love and affection. You know very well, if I am giving something because of natural love and affection, it is also valid. Then the past voluntary services, section 25(2), section 25 subsection 2, past voluntary services, if you acknowledge that in writing. Then promises to pay time bar debt, section 25 subsection 3. And then we have been given section 185, creation of agency. Creation of agency as well. Then you can mention few cases, because in case of agency, no consideration is required. That is the exception I have mentioned over here. Then you can quote few examples, few cases if you remember. Otherwise, just try to give the examples by giving the illustrations over here. Simple. Okay. Then, what are the essentials of an agency? How an agency is created and how it is terminated. So when you talk about the agency, now once again come to the relevant provisions of agency. Okay. So in case of agency, we know very well that what is agency actually. So first try to explain the provision of agency. Try to explain what is the provision of agency. Okay. And then try to mention about section 182, whereby the agency has been defined, and then about the creation of agency. So when we talk about the creation of agency, section 182 about the agency, then when we talk about the creation, you can mention over here, agency can be created by the actual authority, by operation of law, or in case of emergency. Okay, for that purpose, you can refer section 186, 187, by the actual authority, express or implied authority. In case of emergency, section 189 you can quote over here. In case of emergency, in case of by operation of law. In case of, you can say, like for example, section 183, 185, they provide by operation of law how agency is being created. Okay. Also, by ratification. So section 196, 197, by ratification as well. So these are the four ways by how the agency is being created. And when we talk about the termination of agency, then we have to refer section 201 and 202 of the Indian Contract Act. Simply just write down these sections if you remember. Otherwise, just mention the concepts, how agency is created and how agency is terminated. Simple. Time is an essence of contract. What are the remedies available to the aggrieved party in case of non-fulfillment of obligation within the stipulated time period? So, in case of termination or non-fulfillment of the promise, what are the various remedies available to the persons in case of Indian Contract Act? So, it is mainly about the remedies. First, start mentioning about remedies for the breach of contract, and then mention about the various remedies which a person can claim. Okay, so in this case, because the main focus of this particular point is because it is focusing upon time as well. Time is an essence. So over here, we can write down first of all what kind of remedies a person can claim. So that can be damages, basically liquidated, unliquidated, then journal and special. And when we talk about the special, so you have to just focus upon the Headley versus Baxendale case as well. And you have to just focus upon the section 73 of the Indian Contract Act. Section 73. And then the kind of communication at the end of the, the other party takes place and how this measurement of damages takes place. Like for example, normally the difference between the prices is the main crucial criteria at the time of the breach of contract is necessary. And then you have to give an example. If a contract is breached before the actual date of the promise, then it is the responsibility of the plaintiff to recover his damages by entering or into some other kind of contractual obligation. Because if the, for example, defendant is already communicating that I will not be able to fulfill the promise on 30th of October, and he is communicating this thing on 10th of October, then it becomes the responsibility of the plaintiff to manage his situation from 10th of October only, because now the defendant will not be he is not liable to make payment of the difference at the time of 30th October, because from his end, agreement has been breached on 10th of October only. So by this way, you can also quote this kind of example as well in support of this time concept, because it is specifically with respect to time. So by this way, just write down and try to quote examples actually. So just try to quote down the examples over here. So your examples will make your answer complete. Okay? And last, Section 3D of the Patent Act 1970 and the context of Novelties Case. Let me just bring this on record that this particular question is also a part of CLD, because in CLD we have seen the focus of the of this UPSC is mainly about the contemporary developments which are taking place. So in this case, one thing which is necessary to mention over here, why this question came this time, because of one of the case which have just taken place recently, and let me just put this on record. The citation is a little bit kind of, just write down this citation. Chugai Seyaku Kabushiki Kaisha versus Controller of Patents, Delhi High Court. It is judgment of Delhi High Court of 6th of April 2022. So this case actually has happened recently. That is the reason this question came this time. And in this case, let me just mention you what exactly happened in this case. The company was using a method of, basically they were producing a solid tablet, solid form of the medicine in the form of tablet of pre-existing drug via direct compression method. So they were asking for the patent of this drug as well, which was earlier, which is available already in the market in the different format. So company was claiming that we are using a special kind of compression technique and making it in a tablet form, so it should be patented. But Delhi High Court rejected this contention and clearly told that this kind of process is not an invention under the ambit of Section 3, Clause D. So when you refer Section 3, Clause D, which simply says the mere discovery of a new form of a known substance which does not result in the enhancement of the non-efficacy of that substance, or the mere discovery of any new property or new use of a known substance, or for the mere use of a non-process, machine or apparatus, unless such non-process results in a new product or employs at least a new rectent. So this will not be patentable. So for the purpose of patentability, you require invention. So this was also the outcome in case of Novelties case. So first you have to explain why this issue is there because of this particular case, if you remember. Otherwise, start writing down about Section 3D. Section 3D, just start writing about this. And then write down about the Novelties case. What happened in this Novelties case? In the Novelties case as well, same kind of thing happened actually, whereby the company was basically trying to get the patent for doing nothing, just to keep the patent in their hands so that they should, charge the prices arbitrarily at a higher rate without doing anything significant in invention. And they were just trying to, keep the patent with them only, because you know very well there is a tenure of the patent actually. So unless and until it is an invention within the meaning of Patent Act, it is not patentable. So you have to just explain what is the purpose of Section 3D, what is the, how patent can be granted, what are the factors for the patent, and then try to give the example of Novelties case. And then if you remember this case, try to give this case as well. Just try to quote this case, okay? And by this way, your answer will be complete. So guys, after doing all this kind of discussion, one thing which I just want to highlight over here, you might be thinking that sir has just mentioned the provisions or the things in a very simplest manner, whether it will be suffice for the UPSC or not. Let me just make it very clear. UPSC just want you to have the knowledge of all these things. UPSC is not asking you to be an expert of everything, and which is not possible. So UPSC just want to check out your knowledge, a simple knowledge, basic knowledge, intermediate knowledge, but not advanced knowledge, not your research or not a kind of research scholar or not a PhD holder. If you start doing research in each and every topic, which generally, many of the persons they say, you have to write down this thing, that thing, or this thing. It is a clear-cut myth or lie. Because UPSC knows very well, it is not humanly possible for anyone to remember each and every section or each and every case. Because you have to ultimately preparing for so many subjects. So just have basic knowledge, which is more than sufficient, and try to write down the answers in such way. Because you know very well what is the score of the toppers. Okay, around 55%. So just try to understand, you cannot write down any perfect answer at any moment of time, because every answer is, if in this way if you complete, your answer is more than sufficient. It is finally complete. So don't make the things complicated. Try to make the things easy. So that is my only advice to all of you. Instead of creating the technicalities or the complication, try to make the things easy as much as possible. Okay guys, so thank you all of you. Thank you very much. All the very best. Thank you.